Today's webinar will begin in 1 minute.
Good afternoon, everyone. I want to welcome you to today's webinar hosted by the National Air Transportation Association titled Airport Sponsors and Aviation Commercial Businesses Addressing Agreement Relief During COVID-19. Before we continue, I'd like to turn it over to Mike France from NATA to give us some updates on the technology we're using today and some procedures. Mike?
Thank you very much, Kurt. Welcome, everyone. Do want to take a moment to have you take a look at your webinar interface. I'll walk you through real quick some things that you may need during today's webinar. First note, all attendees are muted. That does help keep the background noise down so that you can effectively hear our presenters today. We will have a question and answer portion at the end of today's webinar. Beginning, if you are on a PC, that should be your interface on the left. If you're on an iPad, it'll look like the one on your right. PC users, you can minimize the webinar interface panel using that orange button with the white arrow. Just click that, it'll slide out of the way. Click it again, you can bring it back. When we do get to the question and answer portion, there are two ways for you to be able to ask questions. First, and the preferred method, is to click the raise your hand button. That lets us know you have a question. What we will do then is unmute your microphone, call on you, and you can actually ask your question directly of today's presenters. That is the preferred method, as it does allow you to directly talk to the presenters and ask your question and any follow-up that might be involved. However, if you prefer or you are unable to use the audio, you can type in your question in the questions box, indicated by the two red arrows. The last thing, there are a number of handouts that go with today's webinar. You can find those in the handout section of your interface. So feel free just to click on that and be able to download items as you need to. Today's webinar is being recorded and it'll be posted to the NATA website and be provided to all of you via a email after today. So with that, I will step out of the way and Kurt, throw things back over to you.
Thanks, Mike. Hello, everyone. My name is Kurt Castagna, and I'm the current chair of NATA's Board of Directors. And on behalf of the board, I want to thank all of the NATA staff that have really spent countless hours, 7 days a week, these last few weeks, advocating for its 2,600 member organizations, providing input on the constantly changing dynamics that our industry is now facing. Our board's very proud of the NATA team, and the organization is healthy, ideally structured, and as many of you have seen, is active in DC on the Hill and out in the regions at airports, advocating for all of you, working to preserve your businesses, the infrastructure, and the services that really are going to be necessary to assist us all in an economic recovery. Consistent with NATA's mission to support and advocate for positive airport and tenant business relationships, today's webinar was organized. And today we have over 230 representatives of both airport businesses and airport sponsors registered and joining our call. Together with Jeff Coleman and Shelley Ewalt, I am certain you will find today's webinar helpful in providing thought-provoking ideas that you can collectively collaborate with your airports in benefiting and assisting the airport business community. Our plan collectively as a team will be to speak for about 30 minutes and then provide you all time for answers to questions that Mike will help facilitate. I want to now turn over the conversation to Jonathan Fry, NATA's VP of Government and Public Affairs, to review the current status of the CARES Act and airport grants. After Shelley, Jeff, and myself review our thoughts, Jonathan will provide us an update at the end of the presentation on COVID 3.5 and 4 legislative efforts that are underway now that NATA is pursuing. Jonathan, I'll turn it over to you.
Thanks, Kurt. Appreciate the introduction. You are right, Congress passed the CARES Act just a few weeks ago, and general aviation in some respects did all right, and in others we feel left a real gap that I'll talk about a little bit later on. As many of you know, air carriers, both 121 and 135, were got a number of support programs under the bill. Part 135 air carriers were eligible for a payroll support program. We have heard that many of them have applied for the program, and only a few have gotten a response successfully from Treasury to date. There's also a loan program that primarily the Part 121 air carriers are using. I think it's important to note, especially for many of you who are on this webinar, that contractors were also made eligible under the CARES Act. And so if you have a tenant business on the airport that has a contract with a Part 121 air carrier, they are also eligible for support under Title of the CARES Act. However, it has been a bit disappointing that the Department of Treasury is now more than 2 weeks past the statutory deadline to distribute some of that relief. We've heard from many NATA members that did apply and were were not unsuccessful, but still just haven't heard anything from Treasury to date. Now, I want to also talk about some relief that was provided to general aviation airports and airport sponsors under the CARES Act. As many of you know, there was $10 billion made available for airports. That money chiefly went to Part 139 air service airports, with only $100 million made available for general aviation. The FAA released the grant totals just a few days ago now, I guess, and NATA is concerned that many general aviation airports, in fact, over 1,000, received less than $30,000 in relief from those grants. We are pleased that there's enough flexibility that airport sponsors can use that money for other things that they would use any other lawful purpose that they could use airport revenues for. So we appreciate that flexibility, but we have heard concerns from a number of sponsors and a number of NATA members who are worried that that's simply not enough to cover the drastic decline in operations that they've seen at the airport. So I think with that, that's a current update on the status of the implementation of the CARES Act. On CARES 3.5, Kurt had mentioned that. The Senate earlier this week passed a $484 billion bill that folks are colloquially calling CARES 3.5. It's meant to be a bridge between the CARES Act, the larger CARES Act, and a potential COVID-4 package that I'll talk about in just a little bit. That bill provides over $300 billion for a recapitalization of the Small Business Administration's Payroll Protection Program. Many of you are probably familiar with that. It's been extensively covered in the news. And again, speaking to NATA's membership, we've heard mixed results. We were pleased that a few of our members said they had a good experience with their local bank and bankers that they had a history with and working with before, and that they were able to successfully apply and are starting to see the funds. On the other hand, there is a real concern that while this CARES 3.5 or this next package that the House is set to vote on today may in fact recapitalize the PPP, we at NATA are concerned that it doesn't necessarily make any improvements structurally to the program to make it work better. So we'll be paying close attention to the rollout of that program after the bill is passed. The president's expected to sign it within the next couple of days after the House passes it. Expect a press release from NATA talking about in further detail what's in the bill. And we'll keep you posted in terms of whether or not there are any structural changes to the PPP. So with that, I'll turn it back over to our moderator, Kurt.
Thank you very much, Jonathan, for that. I think now we're going to, on the agenda, we're going to move forward, and Shelley's going to talk about various legal aspects and ideas relative to the current conditions and give us some ideas. Shelley?
Yeah. Hi, Kurt. Thank you. And it's really my privilege to be able to speak to everyone here today. I consider it a wonderful industry to have been part of for a long time. And unfortunately, we're having some interesting times now, but I know that this is a tough group of businesses, tough group of people altogether. So my goal is to just talk a little bit about, to provide the baseline information first about, to understand the funding that has been granted to the airports and how and under what conditions or considerations they can use that. So first of all, the funding was made available to all airports that are part of the National Airspace System. Obviously, you've seen some dramatic differences in those levels. General aviation airports with no commercial service or with less than 2,500 enplanements received a baseline funding level. But airports with scheduled airline enplanements over 10,000 passengers received a great deal larger amount of funds, and some are in the tens of millions. The funding amount you can actually see on one of the attachments that NATA has provided to the webinar. Well, we can talk about or debate whether that formula was right or wrong. It reflects the apparent intent of the Act, which was focused on the solvency of the national airspace system for commercial service air carriers and commercial airports. It is important, I think, to realize that the funds are coming from the general funds of the U.S. Treasury, and they're not reducing the Airport and Airways Trust Fund. So now that everyone is understanding what funding is going to what airports, the question, of course, is, well, how to use that. And the airport sponsor is empowered to make a local decision of how to use those funds. That means it's within the discretion of the airport sponsor, but there are considerations and limitations. First, and most importantly, the guiding principle is that funds can only be used for any purpose which airport revenues may lawfully be used. The FAA has an Office of Airports Revenue Use policy, which lays out in a good level of detail what those lawful uses are. But one example of that is all operating expenses, payroll, and debt service is a qualifying use of funds, but it must have occurred after January 20th, 2020. In this case, although the grant funds have been made available to the airports, it's not that the money has just simply been transferred to a local bank account. The airport has to put in a grant application for these types of operating expense use, but it is a 3-page application, which is pretty extraordinarily, comparatively short if you compare what a normal development grant application would be. Another permitted use of those funds would be airport development and construction projects. In this case, the funds can be used to replace the state and local matching amount that would otherwise have been required in an approved grant. The funds are usable to increase the federal share to 100% rather than the 90 or 95% that you often see in a development project. That is good for AIP projects in fiscal year 2020, as well as supplemental discretionary projects. Importantly, the funds cannot be used retroactively in fiscal year 2019 projects. So we can't go back and pay for old projects with it. In this case, the FAA guidance is that the airport doesn't even need to make any kind of special application to use those funds. The ADO office, the airport district office, will already calculate the 100% share and will amend grants that have already been executed. It's also interesting to notice that there's no actual deadline to use the funds. The funds are available until they are expended. Again, they're in that airport account, but the airport has to make actually application for them. But the FAA has noted that they expect airports to use the money expeditiously. One of the limitations is that commercial service airports must keep at least 90% of their individuals employed. Although the retention requirement does not apply to non-hub and non-primary airports. One last category that I want to bring attention to is that granting deferral, excuse me, and abatement of airport business, tenant rent, or fees is a permissible use of funds. But in doing so, the airport must keep in mind certain grant assurances. And what I want to point out there is, although the funds originate from the U.S. Treasury, they are administered by the FAA, and the grant assurances are applicable to varying levels depending on the use of the funds. A full set of grant assurances is not necessarily applicable to the use of airport operating expenses, but they are applicable for airport development projects. In Grant Assurance 22, which is economic non-discrimination, it requires that FBOs that are using a same or similar use of an airport be subject to the same rates, fees, rentals, and other charges that are uniformly applicable. There are a lot of considerations in what is considered the same or similar use, but a reasonable interpretation would be that if an airport were to grant deferral or abatement, they should do it in a proportionally rational method across the entire airport environment of commercial service providers. So it would be considered unreasonable to grant an economic benefit to one or rent abatement to one and not do it to others. There are obviously a lot of considerations there, though. The next grant assurance that is really important is called 24, and that's fee and rental structure, which requires in part that an airport strive to be as self-sustaining as possible under the circumstances. But this does not preclude temporary financial adjustments and measures that would mitigate the extraordinary economic effect that is occurring to FBOs, contractors, and other commercial service providers currently. So that's all I'm going to cover for in terms of the FAA portion. There's a lot there, but you know, many folks, if they have questions, we can dive into that deeper. But I'd like to talk about next are sort of the legal aspects of looking at the lease. I'd like to suggest that looking at the contractual agreements that the airport as the lessor and a business as lessee signed on to is a really important starting place to understand your perspectives and positions. At a minimum, airport-based businesses usually have a ground lease, and they may also have a facility leased. There may also be an operating agreement that governs the operating rights of the lessee. Okay, so you really first want to look at some of the essential terms and definitions. And you want to review, this is a good time to review the key business terms like the term, the renewal options, the starting and ending date, and the minimum service requirements. Are the rental rates fixed, and when are they adjusted? Are they due for adjustment this year? Are fee rates tied to volume levels? And is there a minimum annual guarantee that sets a floor for certain kind of payments? So how are all of these going to be affected by a dramatic change in the volume of operations? The next key one I want to just point out quickly here is a force majeure clause, which is a fancy sounding term for just saying that when the parties enter into an agreement, they both have certain expectations that are unwritten. So a force majeure clause is a contract provision allocating the risk if performance becomes impossible or impractical as a result of an event or effect that the parties could not have anticipated or controlled for. This term usually covers acts of nature like floods and hurricanes, and then acts of people like riots, strikes, and wars. It oftentimes does not cover purely economic events. But the step to take here is to go and read that thoroughly and understand what it means. So look for what actions are excused by the force majeure clause and who is excused from that action. Sometimes it may simply excuse a deadline for completing a hangar project, for example. It may just simply delay the deadline while the force majeure event is occurring. I have seen clauses that excuse only one party, but not the other during an event of force majeure. One of the clues for guidance in understanding what this clause will mean is that is to look through the actual examples that are often spelled out there. So what the clause will say is force majeure, for example, acts of God, hurricanes, floods. Pandemic, I have to admit, is one that I never have seen in a force majeure clause. However, the way they are written are usually to generally suggest examples of what might be covered. So just simply because it does not say pandemic does not necessarily mean that it would exclude it from the obligations of the parties. I will note, though, that economic downturns, no matter how severe, have generally not been seen by courts to be an act of God. They may or may not be a force majeure event, however. So a force majeure event is generally not intended to buffer the party against the normal risks of a contract. But in what we're experiencing now, there may be valid arguments to make about what these events are and how the parties are affected. The next thing I want to mention is just to understand what are the essential obligations of the contract that can be adjusted to mitigate the economic effect without compromising safety. So for example, if the operations of the airport have decreased dramatically, it might be fair to decrease certain services accordingly, and in that way, it would allow for some economic relief to operators to the financial burdens that they are having to provide. The airport might be in the same way. However, airports, especially Part 139 airports, are under a lot greater obligations to minimum services that they must provide. And so I'm going to end there for now and allow my colleague Jeff, I think, to take over some good discussion about how to actually go about thinking about using this information.
Thank you, Shelley. And I want to thank NATA for inviting me to be a panel member and all the work and effort that they've been doing over the last many weeks. Also appreciate the opportunity to present with Kurt, Jonathan, and Shelley on this important topic. I realize this is a difficult time, but we all need to remember that it's a difficult time for everyone, not only the aviation businesses, but also the airports and also the aviation business and airport customers. That is, of course, unless you're in the business of selling masks, gloves, and gowns, then you're doing okay. But what I really want to help you is make sure that you sort of stage your questions and stage your requests to the airports appropriately. You got to do your homework, just like you would do if you were going to enter into a new lease agreement or a lease agreement extension. You want to make sure you have asked all the right questions and have all the information available to you, including the questions you may be asked of when you go to the airport. So the other thing I want to point out too is you do not want to put yourself in default of your agreement, of course, unless that's absolutely necessary. We might find some of us are in positions where they just end up in default because financially they have no other choice. but hopefully through some of these strategies, you can avoid that. Here's some questions that you need to have prepared and try to find as many answers as you can. One is, what is some of the federal, state, and local financial support that the airport has received to offset lost revenues? This includes the CARES Act that was discussed by Jonathan and Shelley previously. What federal, state, or local financial support has your company received to offset lost revenues? What state or local laws have been passed to protect commercial renters? And Kurt's going to discuss that a little bit here later in the webinar. Does your agreement with the airport sponsor have any beneficial or restrictive provisions? And Shelley was talking a little bit about those of the force majeure clause, any kind of adjustment mechanisms, or anything that's tied to volume activity levels certainly could be beneficial for you. Does your agreement have any future capital investment requirements? And I'll tie back to that in a few moments on our strategies. Have you made any capital investments that will revert to the airport sponsor at the end of the agreement? The reason I put that question there is sometimes the airport sponsor does need to be reminded that you have made beyond rent an additional capital investment, which the airport sponsor will be the beneficiary of at the end of the term. It's important that both sides, both the lessee and the lessor, remember all of the pluses and minuses of the agreement that they've entered into and what transpires over the entire term of the agreement while we're looking at this hopefully short event. What are your current minimum standard requirements? Again, this is where you don't want to put yourself in the default of an existing agreement. If you have an obligation to meet the minimum standards, which might relate to hours of operations, staffing levels, certain levels of services. So beyond abatement and rent deferral, you might also need to ask for some adjustment, waiver, temporary related to the minimum standards in addition to an abatement or a rent deferral. Is your agreement based on a response to an RFP whereby certain activity levels were demonstrated? Now, lots of times the RFPs will say you have to do your own homework, you're entering this at your own risk. We all understand that. That's the normal business, but we are not in the normal environment. And so it's again important to remind both parties, including the airport sponsor, when you're asking for an abatement or deferral, that you went into this agreement and you made this capital investment based upon an expectation that a reasonable level of activity based aircraft operations, fuel volumes was going to take place. And obviously, again, we're not in normal situations. Are there any residual based agreements at the airport? This typically applies to airports that have air carrier service, where the air carrier agreement with the airport is a residual agreement, where the air carrier is basically going to pick up any of those lost revenues. Those agreements may be in flux as well during this time period, but you need to understand that some airports may be in a situation that if they decrease their revenue from rents with certain tenants, that it might impact other operators on the airport. And this is one of the cautions and guidance that the FAA Q&A has provided to airports. What information are you willing to share with the airport sponsor? You got to keep in mind that you need to demonstrate why you need abatement or deferral of your rents or fees. And to do so, you may have to share with them certain information that they may not have today related to activity levels, drops in revenues, or drops in operating profit. Have you, as an airport tenant, provided any abatement or deferral to your tenants? They will ask, airports should be asking you that question as well. If you're asking for deferral, are you extending that same ask to your tenants as well? Or have you already, which further justifies your ask of the airport? Are you prepared to offer any rent abatement or deferral with the airport sponsor grants a rent or deferral? Again, same discussion. What guarantees are you prepared to offer if you are provided an abatement or deferral? Maintaining a certain level of service, maintaining a certain number of employees, or other types of offers Again, there may need to be a quid pro quo here in the abatement and deferral. So those are some of the questions that you need to be prepared to ask yourself, have information before you go to the airport and ask for an abatement or a deferral. What are some of the strategies? Well, first, let's make sure we define abatement and deferral. The abatement is the ending or reduction or lessening of something. The deferral is the postponement of an action or event. So let's talk about abatement first. Basically, you're asking, I don't want to have to pay rent now or pay it back into the future for a certain period of time. Now, keep in mind, sometimes people are just thinking full abatement. And this goes back to that question of, well, what level of activity have you been impacted? Do you still have tenants paying you rent? So maybe a portion or a reduction in rent as far as abatement versus a full abatement of rent would be appropriate. The deferral can also be the same. The deferral can be a full deferral or a partial deferral. And of course, it's for a set period of time. And that's where some of that negotiation comes into play. How long are we talking? What will be the triggers for that deferral to come back on? Is it just, it's for 3 months, it's for 6 months, it's for 1 year? Or is it once fuel volumes return back to 50% or 75%? There needs to be some kind of trigger that actually starts the deferral or ends the deferral. Was talking with a client, they actually have in their agreement, one of the first ones I've seen, where if volumes drop 75%, then rent is adjusted accordingly. Now, I don't think either side ever thought fuel volumes were going to drop 75%, but here we are. One of the other things that you can do to keep in mind on a deferral is the deferral is just moving the pain. It's really not helping out an aviation business financially by just moving the payment from 1 month to a different period of time. So one of the things that an airport could do, in addition to deferring rents, is also extend the lease agreement so that the operator has an extended period of time to achieve their return on investment that they've made, especially if they've made capital investment. And that lease extension can either be proportional to the deferral term, or they could tack on 1 additional year for that deferral. The other is maybe if you have a capital investment requirement. This goes again back to the question that I asked, if your agreement requires this, you could use that deferred rent as a form of payment towards that capital investment. So you could use deferral of rents as a reduction of future capital investment. Keep in mind that what the airport does, and this is guidance from the FAA, to be compliant with their airport grant assurances, what they do for you has to be considered in what they do for other tenants of the airport. But what they do for you doesn't have to be done exactly the same for other tenants. The structure can be different. One could be an abatement, one could be a deferral, one could be a deferral and a lease extension. There could be different structures. It's just that they can't be unjustly discriminatory in the way they do it. Not every tenant is similarly situated, so they don't have to have the exact same abatement or deferral grant to every single tenant the same way. The other thing that I'll just end as a note on here too, circling back to the discussion of monies that airports may be getting through the CARES grants, is that if you're part of a system airport and just on one of the general aviation airports, monies that a system airport sponsor receives, they do have the latitude to utilize those larger grants that the air carrier airport received to help offset revenues at the other airports as well. So I'll end my comments here and happy to answer questions once we wrap it up. I believe it's to you, Kurt.
Thanks, Jeff and Shelley. Really appreciate the insight you guys provided, and this information will be available, the recording, so the folks listening today will be able to get access to it. I just wanted to quickly touch on a few key points that we're seeing in locally in some airports around the country, is that where airport sponsors or their either city or counties are looking at policies that deal with abating or delaying commercial rent eviction or commercial real estate evictions. And these city policies are being enacted at the supervisor city council level, but it brings into question the alignment with airport policy in the regards to some of the programs Jeff was suggesting, and Shelley, the legal aspects. So we've seen these programs where they're typically through May 31st, 2020, and that poses a challenge in itself because the economy hasn't opened up. And so whether or not that's enough time for any city-sponsored program, it might need to be extended. Restrictions on staffing for more than 500 employees poses a problem for our airports that have large employers or publicly traded companies or multinational companies. These are restrictions that we've seen in some of these ordinances, and they're not waiving rent, they're deferring, and there's a 6 to 12 month payment program. The challenge with these types of programs, though, is that they're being implemented for commercial tenants inside the airport sponsor's jurisdiction, and where it might become where we have to be mindful for both airports and airport tenants is the subtenant operators in those facilities that might take advantage of those programs where they're making the request or the statement that they can't pay, and they're invoking their rights under these policies, and therefore not paying the master tenant the rent and creating this program. And the master tenant has no legal jurisdiction to either process an eviction and has to comply with this 6 or 12 month payment program, creating additional cash flow challenges for the master tenant. So the recommendation here is that airports and communities and airport tenants align on how such policies might relate to the commercial aeronautical users at the airport, so that the programs that can be implemented, as Jeff said, can be uniform, and they're not going to be established where they create grant assurance issues. The other aspect is the supporting documentation that communities or airports might want in regards to demonstrating an applicant who's requesting relief or invoking their rights under eviction. Is what is supporting documentation? It's very vague in some of these ordinances, but we do know at the minimum it is going to be demonstrating economic need and proving possibly that each applicant is making every effort to apply for the programs that are being either legislated federally or locally for relief. I think members have to be mindful of their financial data as it becomes public in these cases. And at the same time, airports or where policies require audited or certified financials, that will be a very problematic process, since many small businesses don't do that. And so the hurdle should really be that they're certified accurate, quote unquote, accurate by an officer of the entity or a third-party accountant. So these are some of the pitfalls and hurdles that are the alignment of these ordinances and these economic needs and demonstrations that you have to be mindful of as you're working with your airport sponsor and your community. And so that kind of completes the three of us talking. Jonathan, I don't know if you had anything you wanted to touch on relative to COVID-4 or and just what NATA is doing in those regards for the folks on the call, and then we can answer any questions.
Of course, thanks, Kurt. And I do want to thank Jeff and Shelley and Kurt. I think both Jeff and Kurt really emphasized an important point, right? That as you are having discussions with airport sponsors, I think we all need to be mindful of not simply moving the pain or the difficulties, downstream. And to that end, NATA has been actively engaging Capitol Hill and discussing, where the gap was between the relief provided in the CARES Act and general aviation businesses and stakeholders that were left out, and how we can potentially seek additional assistance as Congress considers more relief packages. Again, the bill that the House is set to vote on today has a real small business focus. We anticipate that that will recapitalize the PPP, and that's great, but we think that as we go into a larger, broader COVID-4 package, that may be an opportunity to seek additional relief specifically for aviation businesses. And so in discussing what that looks like, we have heard from Capitol Hill that it's, in order to be politically palatable, probably still needs to be couched as primarily a payroll program, a payroll support program for general aviation, airports, and their tenant businesses. But that also maybe there is an opportunity to get additional relief for operational expenses. And so that, of course, potentially could be things like lease obligations to the airport sponsor. We're really in the early stages of conversation at this point, but I'm really hopeful that Congress will understand the importance of general aviation, specifically as it relates to the commercial air carriers. In fact, the point that we would contend, and in fact, Tim Obitz, NATA president and CEO, and myself just had with a couple of Capitol Hill staffers, was really that commercial aviation needs GA to survive. It's really an interconnected ecosystem, and so we believe that there is good standing to ask for additional support for GA. On a timing note, as Kurt mentioned, we're originally hearing that this COVID-4 package could be a May timeframe. I think that's certainly still possible. Senate Majority Leader McConnell said in the news earlier this week that he believed this would be a package that would be of a size and scope that he would really need the Senate to convene here in town. As you may or may not know, Congress has been conducting most of their business by unanimous consent, which is an expedited procedure that allows them really to do their business without a quorum or a plurality of their members there and present in Washington, D.C. I do think that the next big COVID package that we see is going to be fairly comprehensive. However, Congress and the White House had originally intended to put a potentially multi-trillion-dollar infrastructure package in with this next big COVID relief package. The conversation that we had today with some Hill staffers on the House side, they are a little dubious that that is the case, and that there is still a desire to do a broader infrastructure investment package, but maybe to make that look a little bit more like the Relief Act that was passed after the recession in 2008, 2009, and that maybe that would be two bills removed. And so the next big package, we may see something that looks more like additional payroll and small business support with an infrastructure package a little bit later on in the year. I don't think that changes NATA's calculus. Again, the majority of general aviation businesses are small businesses, and so we do think that we have good standing to continue to discuss and negotiate with Capitol Hill, and so we'll keep you posted in that regard. I'll turn it back to Kurt.
Thank you very much, Jonathan. Appreciate the work you're doing on the Hill. Mike, I know you might be collecting questions that you might want to throw to the panel.
Absolutely, Kurt. Thank you so much. Quick reminder to the attendees today, there are two ways you can ask a question now of our panelists. One is hit that raise your hand button. I'll turn on your microphone and you can just ask your question. The second is with the question box there on your webinar interface. Just type in the question, hit send, and we'll get to it. It usually does take a moment for some of these questions to percolate through, but we do have a question right now. Jeff wanted to ask a question, so I'm going to go ahead, not Jeff, our presenter, but Jeff, the attendee. Jeff, I am unmuting your microphone right now. Would you like to go ahead and ask your question?
Can you hear me?
Absolutely.
Yes. Okay, great. Thank you. This is Jeff Barkowski. I'm a Part 135 operator and also run an FBO at a small general aviation airport. From my reading of the program application supporting documentation and some of the information that you all have provided, my question relates to the Treasury's payroll support to air carriers and contractors grant and how that relates to the Small Business Administration's PPE loan. The way I understand the payroll support grant is that there's not a deadline associated with when the funds have to be used for. It's just that the restriction is that they're used for payroll support, whereas the PPP loan is to be used in the next 8 weeks, and that's what after you've received the disbursement. Is that a correct understanding? And if so, does that mean an organization could use the SBA's PPE funds for payroll in the, say, next 8 weeks, and then use the Treasury's payroll support grant if that was also received after that 8-week period?
So Mike, I'll take first pass at the PPP loan, which I'm more familiar with than the other grant that is being provided. The 8-week period is related to the forgiveness of the loan, and it's related to expenditures with rent or payroll, rent, utilities, and interest on debts that were entered into prior to a certain date. But the forgiveness, that's what the monies can be used for. The forgiveness is related to that 8-week period. So you can use it for expenses beyond the 8-week period. It's just that it won't be forgiven at that point.
This is Jonathan. I would just chime in to say I think Jeff's understanding is correct. And so as recipients of both PPP and the Air Carrier Support Program, I do think that there is a real consideration in terms of timing there. But Jeff makes a good point that there's potentially more flexibility with the PPP.
We've also got NATA President and CEO Tim Obitz on the line here who wanted to chime in. Tim, your microphone should be on now.
Great. Hopefully you can hear me, Mike.
Absolutely.
Good. So you were, Jeff, you were partly correct. So Jeff Coleman is correct as the 8-week period. That determines the level of forgiveness, and you can use it for the 4 things. There is no expiration as to when the program support program agreement funds under the Air Carrier Worker Support Agreement can be exhausted. So our advice obviously has been to keep the PSPA or PSA funds under the Title 4 Subpart B separate, and obviously only use those for payroll. And as the funding has been at a 76%, obviously some of the payroll funds obviously can then be used during that same time frame for the PPP. You just can't double count on them. So make sure it's clear as day is long, because the worst thing you want to do is to be blamed for double counting. But you are right in that fact that there is no exhaustion period as to when the funds under the Air Carrier Worker Support Agreement have to be used. They just have to only be used for payroll.
Thank you, Tim. Just also want to let all our attendees know, I see we got a number of questions rolling in here. Be patient, we will get to you. So we're not ignoring anyone. They're stacking up here, and we'll move through all of them. I've got Matt on the line who would like to ask a question. So Matt, we're going to go ahead and unmute you. Matt, you want to go ahead and ask your question?
Yeah, can you hear me?
Yes, we can.
Hello? Okay. Matt Nevkin with Phoenix Mason Gateway Airport in Mesa, Arizona. So the use of the funds for the payroll support, I'm trying to understand, does that mean that we keep our employees at you know, full hours, or is it just to fund? Because obviously we have reduced operations, and so we've reduced our schedule. Is it to make up what's lost, or just pay for what is going on and be able to stretch that out over whatever period of time this lasts?
Thanks, Matt. Who on our panelists would like to take that question?
I'll take a shot at it, and Tim can always come in and correct me as well. Is that
I'm going to turn his microphone on as well.
is that certainly you can use it for your payroll that you have in place. And again, if this is related to the PPP loan, Tim can probably speak more to the other funds that are available.
Yeah, so the question I thought was to the payroll support program agreement under the Air Carrier Worker Support Program as a contractor to the airlines. Is that the question? How you
That
can
is
use
correct.
it? Yep. Okay. So you can only use those for payroll. You are going to agree, and they had not processed the contractors yet. However, in the guidance that they put out yesterday, that's dated the 20th, even though they put it out yesterday, there is the agreement in there attached, so you can see what you will be having to sign to receive the funds. And in there, you're agreeing to keep your payroll at the same level as the date you execute the agreement. So you want to use the funds to pay for payroll. I mean, that's the only thing you can do with the funds is to use them for payroll. And so going forward, you're agreeing that you're not going to be reducing your payroll. And obviously, if you add people back up, you can use those funds. In other words, you increase your payroll, you can use those funds for the increased payroll as well. The goal is you can't reduce your payroll. Otherwise, you've got a problem with Treasury, and they might seek the funds back.
All right, thank you, Tim. All right, we've got a number of other questions that came in via writing, so I'm going to read a few of these out to our panelists, and I'll let you all decide who should take those. First one, just as a real basic question, who should we contact at the airport for questions about what they might be willing to do?
This is Shelley, and I would start with the airport manager. And, you know, so depending on the size of the airport, that might be someone who's accessible to you or not. But for most general aviation airports, that would be someone who's accessible to you. If it's a, you know, extremely large, you know, Newark or something like that, you're probably more commonly dealing with like a properties manager or something like that. But if you have any existing relationship with someone, that might be the place to start if you cannot find yourself getting in contact easily with someone who is responsive to you.
Thank you, Shelley. Our next question says, yeah, go ahead, Kurt.
Mike, I would just add that, you know, recognizing that we have airports and businesses both on the call, it's really important that we deal with the political aspects of this very sensitively. I think working through your airport and staff and building a plan and with the stakeholders that meets all the objectives and the guidelines is important. I think there's obviously an educational piece to this, though, of what airport businesses as a collective group around an airport need to do in educating what the losses are and impacts are, so that the elected leaders and policymakers on their boards or city councils are aware of these actions. It's not to pit the two parties to off of each other, but it is really to align all the expectations and the understanding of what the losses are. So I would just advise the businesses and the airports to work together in that regards.
Thank you, Kurt. So our next question is regarding to the funds that the airport sponsors receive. I just wanted some clarification. Is the money that the airport sponsors receive in addition to AIP projects being done at 100%, or does the money that the sponsors receive go to make up the match to make the project 100%?
Yep, this is Shelley. So it's the latter of the question there. The funds that have been made available to airports are making up the usual 10 or 5% in order to raise the total grant to 100% funded.
Very good. Thank you, Shelley. Next question wants to know is can the CARES Act funding be used to abate rent for non-commercial hangar renters?
And,
Yeah,
and
go
go ahead, Shelley.
ahead. Oh, I'll just say that there's no reason why it can't. It is not purely limited to commercial service operations. But with that caveat, I'll let Jeff answer. He might have some thoughts too.
You know, we're in line, Shelley, and I think it goes back to the defined allowed uses of those CARE grant money, and that is any permitted use that airport revenues can be used for. And so since airport revenues comes from many different sources, including commercial, non-commercial, aeronautical, non-aeronautical, and otherwise, that any abatement or rent is obviously a revenue, and the CARES grant is designed to offset the impact of lost revenues that the airport would incur. So you could abate or defer rent of a non-commercial or non-aeronautical entity.
Thank you, Jeff. All right, our next question is rather long. I'm not going to read the entire question, try to kind of summarize. It's in relation to the idea of fairness in what actions an airport may take related to, say, the grant assurances. A few key points that our attendee was asking was, when we talk about the actions needed to be fair to all tenants, does that mean only aviation businesses or all tenants like a GA restaurant or other airport tenant that does not provide aviation services? And also wanting to know, when we say fair, if you give help to an FBO, must you also give help to a flight school that's not part of an FBO? Just could you panelists kind of expand on what those considerations might be?
Yep, that's a great question, and it gets to the core of how Grant Assurance 22 actually works. 22 is economic non-discrimination, and it does not say that every tenant of the airport has to pay an identical amount or be subject to identical terms and conditions. What it does say is that you should treat similarly situated businesses in a similar way. So purely under the FAA's guidance, you generally would not consider maybe an FBO to be similarly situated to a flight school. But that doesn't mean that both could not be given consideration for what they're going through. And so I guess the way I'd like to frame it is they are both likely facing severe economic depression because of the operation descent that has occurred. The airport under Grant Assurance 22 should take that into account, that maybe both are using the airport for obviously aircraft operations and both have been affected, but it does not require that they be granted exactly the same kind of consideration.
Shelley, a quick follow-up that goes along that line. If you do receive some consideration from your airport, and whether it's abatement or any of the other types of things that we talked about, is there any requirement that as an airport or an aviation business on the airport that then you extend the same types of offers or ideas, principles down to your tenants?
No, there wouldn't be that requirement, although you might be considering that depending on the circumstances, if it would help you to make a more compelling case in the overall case of the economic picture that you're trying to present and share between the airport and all of the tenants as a partnership.
Very good. Thank you, Shelley. Just again, we have a number, it looks like right here, we've got about 10 or 12 questions left. I assume our panelists are okay to just stay on the line and keep working through these?
Yes.
As we are closing in on the end time.
Absolutely. We'll stay
Our
on.
next question, okay, great. Our next question wants to know, it's kind of a two-part question. Number one, what are we seeing in terms of airports' willingness to abate or defer rent? And also then wanting to understand what are the competing uses of this funding that an airport is considering, you know, in opposed to providing it to abate or defer rent.
I'll just say that our firm has been receiving lots of calls from airports wanting to get guidance on what they need to do, what the best way to do it is, what other people are doing. So I would say that lots of airports are considering it. I've only have confirmed a couple or three. We've helped write a policy for one that is going to provide some deferral. So it is happening out there. In every situation, it's a little bit different. But again, this is what I encourage each of you to do your homework on how best to present and convince your airport sponsor that it's in their best interest. You know, making sure that commercial aviation businesses are economically viable going forward is in everyone's best interest. This is just not a financial play by the aviation businesses. This is making sure that you can continue providing your services once this has passed. So it's really best to approach it as a team effort.
Jeff, Kurt, I would just echo that and say from another perspective is that the airports somewhat it's a very convoluted process, and I think there's a fear that they don't want to implement something that's long term or leveraged, where the benefit is you know, used for other purposes. I think, you know, you want to certainly consider whether or not where the tenant's standing was with the airport, whether it was financially viable prior to COVID is probably one factor to look at. Something that's been talked about where Jeff mentioned lease extensions as an option in certain conditions, that would be a very viable option that in some ways doesn't cost the airports anything but possibly short-term extensions on the back end of leases in exchange for paying current market rents to those operators at the airport that wish to do so or have the means to do so, is a mechanism to keep airport valuations higher. And so that's a consideration that airports should look at, because the next potential shoe to drop is not just the rent relief, but what the impact of this is going to be on valuations.
All right, a quick follow-up, Shelley, to the question about the similarly situated businesses. So this is relating to flight school again. The question is, so would a flight school that is renting property or facilities directly from the airport might be considered not similarly situated to a flight school that, say, just has a rents directly from an SBO? You might see differences in the approach between those two, and that is the airport's discretion. Can you shed any light onto that?
That would be correct, Mike. I mean, they while they're providing a similar service, they are not similarly situated because one's leasing from the airport, one's leasing from the FBO, and clearly the airport has no ability to grant any abatement or deferral to the flight school that is leasing from the FBO.
Okay, thank you. Our next question, to keep moving here, is can a business get both the Paycheck Protection Program SBA loan and payroll support assistance?
Yes, they can if they meet the qualifications for the program. The qualifications for the Treasury program, that is geared towards airlines, air operators, but it also covers Part 135 operators, and it covers contractors such as an FBO to the extent that they are providing services to a Part 121 carrier. The SBA program, or the Payroll Protection Program, is basically broadly available to all businesses.
Thank you, Shelley. All right, regarding the PPP, what is the difference between the 8-week disbursement requirement and the June 30th rehiring cutoff?
Don't know the answer to that one.
Yeah, I don't know either. Sorry.
I'm going to unmute Tim here and see if he may happen to have an answer for us. Tim, just unmuted you, but I'm not sure your audio is working right now. Can you hear us?
Okay, I'm unmuted now. I
There we
muted
go.
myself. I apologize for that. So there appears to be confusion here. Under the CARES Act, Title I, and the PPP, the 8-week period is to determine the amount for forgiveness of the loan. So you are using funds to pay for payroll, lease obligations, mortgage interest, and utilities. And whatever you pay during that 8-week period is the amount of forgiveness of the loan. The June 30th date is you're agreeing to keep your employees around and your payroll levels at a certain level, not to be reduced below a 75% level, to determine a multiplication of the 8-week period of expenditures multiplied. If you dip below certain payroll thresholds or employee thresholds, then that 8-week period expenditure then is reduced by that percentage of calculation. That's what it's about. It's a simple math formula that's not so simple. And I'm happy to talk with people about the PPP and the Air Carrier Work Support Program ad nauseum. My cell number is 703-678-5833. I probably get 35 to 40 calls a day with people asking questions. I point them to the statute and to the guidance, and we'll tell them to call people like Shelley or Paul Lang or David Norton or other aviation attorneys that know stuff if it gets to the point where I'm tendering legal advice, even though I am a recovering attorney.
Thank you, Tim. I'm going to go ahead and leave you unmuted and let you handle muting and unmuting yourself. A couple more, I actually still got a number of questions left. We'll keep moving through them. The next one says, we're not clear who sends in the application to receive CARES Act funding. Will this be sent directly to airport sponsors or FBO operators?
So the CARES grants that's related to the airport funds is dealt with between the FAA and the airport itself. And the airports, most airports have been notified the monies that are available to them, and they have many times been provided a link for the grant application. And that's all done at the airport side. Aviation businesses are not part of the airport grant portion of the CARES Act.
Thank you, Jeff. Our next question wants to know if any of our panelists would be willing to comment on the FAA's view on how airport grant assurances will affect an airport's decision to offer rent abatement versus rent deferral.
I'll
Good,
talk about that, but a little bit off the top of my head, and Jeff, please chime in. The first one I think they're going to think real hard about is the 24, which is the requirement that they be as self-sustaining as possible. And that's going to cause airports, to lean more towards deferral rather than purely abatement. I'm not sure that Grant Assurance 22, economic non-discrimination, is going to play into that decision so much, as long as they're treating businesses generally similarly, and they have a rational methodology for it. But certainly 24 would play into that, and that would lean towards a deferral. And Jeff, what do you think?
Yeah, I was just going to add in that one of the handouts, I believe it's the fourth one, updated information for airport sponsors considering COVID restrictions or accommodations. And on page 3 and 4, they have the FAA, I thought, did a really good job of outlining their guidance related to rent abatement versus deferral, and that the act of doing that would not violate, in most situations, Assurance 22 or 24. But there's additional guidance in there. I encourage, again, doing your homework, reading this guidance so that in case the airport sponsor hasn't, then you're prepared to provide them an answer if they say, well, this might violate the assurances.
Mm-hmm.
All right, thank you. So next one's just a quick clarification. One of our attendees wanted to know the name of the program that will help with paying payroll, not the PPP, but the other program.
Sure. That's the Air Carrier Work Support Program, and it's under Title IV, Subpart B of the CARES Act.
Very good. Thank you so much.
And the deadline.
All right, so our next. Oh,
file,
go ahead, Tim.
Files Monday. That's a clear thing. Is the deadline to file is Monday for that relief. So if you think you're eligible, please give me a call. I'll help you on this one because you need to get it filed. And
I'll point out to all our attendees right now the email address that's on your screen directly under the word questions, covid@nata.aero. If you have any follow-up questions, and we have a couple more that we will get to here. I got 4 more questions. But if you have any follow-up that come up after this or you need additional assistance, please send you an email to that address. It goes into a system where we're then able to disperse it to the appropriate person within the association, be it Tim or Kurt or anyone else we can do. So the next question for our panelists is it your understanding that only PPP funds expended in the first 8 weeks will be forgiven? Since this is 2.5 months payroll, can the PPP funds expended in the form of a PPP COVID-19 bonus to all employees? And I'll reread that if you need me to.
Sounds like the question is can you prepay to stay within the 8 weeks?
I'm not going to provide legal advice on that one.
Yeah.
I'm going to suggest that just that you look back, whatever your application was that you based your payroll on, that your payroll should be staying consistent with that application. I would start with that.
All right. Last question here. Is there a recommended email to use for Treasury to amend a previously submitted application for the payroll support to air carriers and contractors? Somebody noted that they did try to call to do this, wants to know if there is a contact, another form of contact.
There is not. It's a frustrating thing. We've raised the issue with Treasury. If there is a defect in the application, Treasury will come back to you and ask for additional information, or when they contact you at that point, please respond to them saying, I need to amend it. There was a mistake in the application. But obviously the deadline for filing the application is Monday, and you hate for the thing to be thrown out because of a defect technicality. So if the person would contact me, we'll see what we can do to try to help expedite that process. Again, so that Tim Obit speaking, 703-678-5833. Thanks.
All right, Kurt, that wraps up our questions. So I will
Mike, can I ask a
turn it
quick
back to you.
question?
Yeah, absolutely.
This is for Shelley. Shelley, back to the force majeure provision, and I realize lots of times it will state what is allowed under that. But the fact that both the federal government and many state governments have declared disasters within their states, does that provide some credence to the force majeure?
Well, it might play into it. You know, by case law, just a declaration of national emergency, or what you often see in those clauses are declaration of emergency or war are grouped together, and they are separate from a force majeure event. The declaration of emergency are oftentimes used in the case of a taking, taking meaning like a condemnation of your premises or use at the airport. It doesn't have to necessarily mean that some, you know, supervening army came in and actually physically took your property. It can mean that simply the property was unavailable to you. And maybe an example of that would be, say, an airport was taken over and used for military purposes. So the declaration of national emergency, I don't see a lot of interplay of that with force majeure that necessarily applies here.
Great, thank you.
Okay, with that, we really want to thank everyone for attending today's webinar. And just as a reminder that it will be available, the recording will be available to folks through NATA. And with that, we will close our session.
Thank you, Kurt. Thank you,
Thanks,
Shelley.
Jeff. Thanks, Shelley.
Thank you,
Thank you.
Kurt.
Thank you, Mike.
Thank you, everyone. Have a great